clarification of one of the questions that you had. I'll read again from the 1999 consent decree. Actual language from the consent decree. The team shall not meet or correspond with the DEQ ex officio member without providing representatives from the Attorney General's office and defendants copies of such correspondence and an opportunity to be present.
My understanding is, again, I wasn't there, but my understanding is that at the very first meeting that the team met, they asked if they could meet separately with Joe England, the ex officio member, and it was PSF's attorney who said that that was okay. So I understand that's in there.
I'm just reading from the consent decree. I don't know what I was talking about before you or I were even part of that process. I'm just reading right from the consent decree.
And that is in there, but at the same time, it's been 10 years since that meeting, and this is when it's being brought up. So it's a little bit late in the process to be saying suddenly, we didn't like how it went on for 10 years with Joe England meeting with these people. Yes, that's in there. I'm not going to argue about that. That is exactly what it says. You read it correctly.
Hi. Mr. Allen is a tough act to follow. My name is Holly Boxley, and I'm a proud employee of Premium Standard Farms. My husband Blake is here with me tonight. He's also an employee of Premium Standard Farms, and together we have 18 years of service with the company. I have two questions that I'd like to ask tonight. The first one is, has the team done any testing to validate claims that alleged odor at the neighboring sites persists after PSF has implemented new low-pressure land application methods, installed lagoon covers, and constructed A&D technologies?
If I may, the short answer is yes. There's been a number of odor evaluations, not only alongside specific technologies as part of the R&D process, but at locations that would represent the periphery. And I seem to recall, and it's been a while since I don't read my mammoth stack of files that my wife wishes I would get rid of, but I haven't yet. Coextensive with the community survey that Brian Paulson referenced earlier in one of the accomplishments. Coextensive with that was an odor study by Iowa State University around the periphery and at certain receptor sites downwind. So the short answer is yes, without digging through large stacks of files. I think that, let me say this, the odor measurements at those sites were not remarkable in the sense of being off the charts. I do want to add further that the state of Missouri has an odor standard of 7.1 dilution to threshold at the property line, and regardless of whether over and above and beyond any consent judgment, that regulation has been in effect now a number of years, and it is at the very least a backstop, if not something that provides a measure of protection to the public vis-a-vis all agricultural operations, and in fact operations in general commerce. So the state of Missouri has provided for that's above and beyond the consent decree by way of attempting to protect their citizens. I've been involved in a couple of odor nuisance suits in the state of Missouri, and so I'm very familiar with that 7-to-1 dilution to threshold level.
My second question, what scientific basis did you use to come up with 80% for barn odor reduction? Why is 80% the magic number?
Okay, 80%, I think because of the, odor is a, has a logarithmic approach, and if you reduce it by 50%, you really can't tell it that much. So you really have to have a fair amount of odor reduction to really be able to tell that, or be able to indicate what kind of, if there is significant levels. So I think, and that's a pretty common thing for dispersion modeling, which is used to basically measure the impact at the receptor. 80%, I think, has been used as a reduction level, a target for a lot of odor control technologies, including biofilters, including other technologies.
Ms. Foxley, in response to your first question.
I wouldn't mind taking a crack at that as well. If you take a look at the, going back to what I mentioned before, that the Missouri standard of it's about 7-to-1 dilution. If you go back to the instrumentation that was based on, there's another, the next higher readings for either, one of my recollection, either 15-to-1 or 31-to-1. And so if you, anything in the 30-to-1 dilution ratio using that specific instrumentation, it is an unacceptable odor. So it is also a way to say that a 7-to-1 dilution represents about an 80% reduction over something into the 31-to-1, 35-to-1 ratio. So it's another way to reinforce that if you were close to what could be anything, a furniture factory or an animal feeding operation, or a municipal landfill or a municipal wastewater treatment plant or anything that had something in the 30 dilution ratio, I think you would find it uncomfortable. And so with something in the order of a 7-to-1 dilution ratio, it gets you it's roughly approximately 80% reduction. And I think that's part of the logic. I also think that it is something that's considered achievable based on what we have determined, read, some of our own research from other studies. So, and I'm reinforcing what Larry said. Odor intensity, as perceived by the human nose, it is on a logarithmic scale. So, if you cut it in half, you really concentration in half, you really only cut odor intensity by less than that, it's about 0.7. So it's just something to consider. But yeah, there are technologies that have shown that they in research that's achievable, at least within the bounds of research if it's conducted in. But it is a high bar. I would tell you it's a high bar.